Good morning. It's a great day here at Elville Associates, and welcome to our Elville webinar series. My name is Jeff Stauffer, Community Relations Director here at Elville Associates, and I'll be your moderator today. I'm pleased to share with you our topic, which is guardianship. What is it? When is it appropriate? And what are some alternatives? Presented by Elville Associates Managing Principal and Lead Attorney Stephen Elville. This is a matter that we guide many clients through here at the firm, and you're in the right place for a broad and high-level discussion today. With that said, we encourage your general questions today, and so please note them in the chat or question section on your screen, and we'll pause periodically to address them. Your questions always help the presentation. They add value, help others learn, so don't be shy in posing your questions at any time. And yesterday by email, you received the presentation slides from me that Steve will be referencing. If you didn't receive this email for some reason, they're also available in the section marked handouts on your screen to download at this time. We also have several professionals on today's webinar, so thank you for being here as well. And as is always the case for our webinars, 1.5 continuing education hours are available for most everyone in attendance. So if you'd like to receive that CE credit, you can submit an ID number and your accreditation to me. I can provide a certificate, or if you're a CFP, I can submit your information to the CFP Board of Standards. Please send the information to me if I don't have it already. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a minute or two to fill out this brief survey and share your thoughts about today's presentation. We always value the feedback that you have to share with us. And here at Elville Associates, we are always here as a resource for your family and you. New planning needs to address, outdated documents that need to be reviewed, or perhaps another matter such as if guardianship is right for your family situation. Steve and our team are here to advise and counsel you throughout those processes. So I'd like to offer Steve and the firm a very brief introduction and share just a bit about us, and then we'll jump right into the presentation. You should be able to see my screen here. Elville Associates, our firm was founded in 2010 by Stephen Elville. We have several different practice areas that we focus on here on a daily basis. We serve hundreds and hundreds of clients and educate thousands of people on a yearly basis. We focus on estate planning and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you from the Columbia Gateway community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we do focus on education a lot here at Elville Associates. We do that in several ways. I'm so sorry, my phone is going off. Steve, I didn't turn off my phone just like you just did.
It must be a late Valentine's Day gift, Jeff.
It must be, yep, somebody's calling me. I was saying, we focus on education a lot here at Elville Associates, and we do that through our planning processes with our clients. We have different programs here to suit all families and individuals, whatever your situation may be. We also do it through educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, we're one of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We were actually supposed to have our first quarter client care program education event tomorrow. It was snowed out for the second time. We're going to forge ahead though, and we're going to have it in March, I promise. But I promised that in February. But we're going to have it in March, I guarantee it. Just a bit about Steve. His work as an attorney for the past 23 years has been centered in elder law, special needs planning, and estate planning, with an emphasis in areas of tax planning and asset protection. A member of many different national membership organizations and professional organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many, many others. Steve works to offer peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. Steve is a very seasoned speaker, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm very privileged to be the executive director of, If you'd like to learn more about the Elville Center, what we do to make a musical difference in the lives of children each day, please reach out to me directly. I would love to share our story with you. But for now, we have an interesting presentation about guardianship, all the alternatives, when is it appropriate. I'm going to turn the presentation over to Steve in just a second here.
Thank you, Jeff.
Make you the presenter here.
Great. There we go. I'm going to show my screen, Jeff, and get my slideshow started. And just let's see if my screen will behave here.
There you go.
Thank you very much, Jeff, for that introduction, and good morning, everyone. I see that there are many of you on this webinar this morning, on this Friday morning, and I thank you. I'm looking out my conference room door here this morning, and it looks like we've got sunny weather, but chilly, and maybe some snow is going to come in. So for those of you who love the snow, congratulations, look like we're going to have some. And Jeff is our weatherman, and he keeps us informed here at the firm way in advance that this snow was coming, and I hope you enjoy. And we're here to talk about a very serious subject on a Friday morning, which is guardianship. And we're going to try to keep it light. As you see, I still have my Valentine's Day, flowery tie on, and Jeff has shed his flowery tie for moving on, but it looks like he might have still been getting some kind of communication there about Valentine's Day. I was just kidding. And without Jeff, we couldn't do what we do here at Elville & Associates, which is bring a lot of education to you. And any success we have achieved here at Elville & Associates has been a collective effort because we are a hybrid elder law firm, I'm proud to say. We deal with a lot of regular estate planning for modestly wealthy clients and also very wealthy clients. We do a lot of elder law planning, all the aspects of disability and elder law planning, and it also includes special needs planning. And years ago, someone said to me, well, gosh, Steve, why do we have so much guardianship work? Well, the reason is that guardianship really doesn't discriminate. Guardianship can be needed where obviously we have families with loved ones with special needs. Guardianship can be needed for an adult. Guardianship can be kind of a topic of discussion when we don't have estate planning documents in place, like powers of attorney or advanced medical directives. And now there's a disability and someone cannot make their own decisions. So what we're looking at today is what is guardianship, what are the alternatives to guardianship, including supported decision making, which is new in Maryland law. And all of these things we're going to talk about. And, I am very blessed to be able to talk to you about this because I know many of you have concerns about guardianship. Some of you are guardians already of an adult child or other person. Some of you are thinking about guardianship. Some of you are wondering about supported decision-making and other guardianship alternatives, and is that something that could still be in play for someone who's already under guardianship? So we're going to try to get into the basics here this morning and give you something to walk away from, something substantive that you could walk away from. And so I just want you to relax, make some notes. We're going to maybe take a couple of pauses. Jeff is a great moderator. He'll take your questions if you have any. And again, I thank you for taking the time to be with us on a Friday morning. And I hope you learned something here. And if we can help you afterwards, we're going to give you a path forward for that as well. This is not legal advice, even though it's going to sound like some of it. We are not in an attorney-client relationship. However, when you engage with an attorney to discuss this kind of matter, even if you don't move forward to actually sign an engagement with an attorney, you are still engaging in confidential discussions with your attorney, even if it's just preliminary, and that is an attorney-client relationship. But this is high-level legal education, I guess, is the best way to put it, and it can't be construed as legal advice. So we're going to talk about what guardianship is. And, guardianship is the most, invasive form of intervention. But we're going to talk about, why. And we're going to talk about the benefits and drawbacks of guardianship. And once you decide to endeavor to go down that road, and some of you know what I'm talking about, it's pretty involved in some cases, and in other cases, it's not as involved, and it's more of a non-contested guardianship situation, which is what we're going to talk about as well. And that kind of leads to this bullet point of the main questions that everyone should ask themselves before they decide to pursue guardianship. And then we're going to talk about alternatives to guardianship, as I mentioned earlier, and next steps. So guardianship is the process of obtaining the highest form of intervention over someone's life. And, some of you are not going to know anything about guardianship, and I'm going to act as if you don't. And some of you probably know quite a bit about it, or maybe even are guardians. And some of the professionals on this webinar this morning, our special guests, plus our professional guests, some of you are going to deal with families that are in the midst of having to decide these same issues. And so this is all very, very good that we all come together for this kind of education for the greater good. So let's assume that you get a guardianship of the person or the guardianship of the property over a person's life, well, or both. And now what does that mean? Well, if it's a full guardianship with a full-fledged guardianship order, that gives you the highest form of intervention over someone's life. They typically lose their legal rights, rights to their person, rights to their property, with some exceptions, and we're going to talk about that. And that's what we're really talking about, getting control of someone's life. And I might throw out some descriptive terms. Because that person is vulnerable, they are mentally incapacitated and cannot appreciate the nature of decision making. And that's what we're going to get into today a little bit, is just to give you a flavor for a very broad topic, which is the issue of what is incapacity today. And is incapacity being interpreted differently than it was in the past? And all of these types of guardianship questions arise to the circuit court level, the circuit court. So just to give you a little bit of an idea of what guardianship is as we start, it is not to be taken lightly. It is not something that is implemented lightly. And the court is the ultimate guardian. So even though you may be a guardian or you may be a prospective guardian, you are not really the guardian. The court is the ultimate guardian. So you are guardian in name, but the court, the circuit court, is the ultimate guardian. So the guardian is responsible to the court. The guardian has to report both personally about the whereabouts and the residency of the person and their health and their current situation, and for their property if you are a guardian of the property. All right, so that will give us a little bit of an idea of how we are starting to frame this idea of guardianship as the highest form of intervention. And a person who would be under a guardianship would be a person who has attained 18 years of age or older in Maryland, and they are presumed to have legal capacity. Now, this whole issue of capacity, again, is fluid as we continue to go into the future at a very rapid pace. We're going to talk about some different notions of capacity versus incapacity. And while this webinar this morning is not about the looking under the hood, so to speak, of the issue of capacity itself, what I hope you'll take away from this is that the definition of capacity or incapacity is now much more fluid, in my opinion, than it has ever been. So if a loved one or other person lacks capacity to manage their personal or financial affairs, a court appoints a guardian, the ultimate guardian, the court, appoints a guardian or conservator, or in other words, a guardian of the person or a guardian of the property or estate. That person is now in charge of that person's affairs, with some exceptions. Sometimes a person can be given the right to vote or to have certain rights under a guardianship, or a consent agreement under guardianship, where it's a little bit short of a full-fledged guardianship and the person retains some rights of review, or they have input into certain aspects of their own decisions. So this is just giving you a flavor of what guardianship and conservatorship is. And as I just mentioned, there are two types of guardianship. One is of the person. This is the most common form of guardianship because not every person under a guardianship has property. And courts are reluctant, in my experience, to issue guardianships of the property where there is not a clear sign that there is property to manage, because the court doesn't want to be clogged up with guardianships that don't really serve any purpose. When I was a much younger lawyer, I didn't really like this, because I felt that parents that are having to petition for guardianship of a young child who's just turned 18, whether that child had assets or not, I felt back then that, well, the parents shouldn't have to come to court again to get a guardianship of the property. The court should just implement both. But that's not how the court views it. So if your loved one does not have property, meaning property that's outside of Social Security, then, and we're going to talk about Social Security in a little while, then the court was probably not going to issue a guardianship of the property if one is not really, really needed. And that's where we get to guardianship of the estate, which we're calling guardianship of the property. And where a person cannot manage their own affairs, their affairs will be managed by a guardian. So what are the benefits and drawbacks? And so as you can see so far, the topic of guardianship is not necessarily a technical discussion. This is a very broad discussion, and we're going to try to keep it light because it's a very difficult subject to talk about sometimes, but it's the highest form of intervention. And this is a redundancy that I'm telling you here just to drive home this information. It's a high form of intervention. It is the highest, actually. If I'm under a guardianship, by definition, I have lost my legal rights to my person, so to speak, my legal rights to my property. Now, does that mean that I have lost all my rights? And the answer is no. Theoretically, I still have some rights. I have a right to be heard. I have the right to counsel if the court deems that I have the right to counsel. I could still sign a will under guardianship if the court allowed me to. So there are things that I could do, including the right to vote. If the court says I still retain the right to vote, I can still have that right. So I can still say that I do have some rights. I haven't been stripped of all my rights, theoretically. Now, guardianship is cumbersome. It always has been, and it always probably will be, because there has to be a proof of incapacity by two physician statements or statements by other professionals that the court will entertain, such as licensed clinical social workers and so forth. Guardianship is tending to be expensive, although uncontested guardianship, which we'll get to, tends to be a lot less expensive than contested guardianship. Guardianship causes a loss of flexibility. Now, what do I mean by that? Well, generally speaking, once a person's property, let's say, becomes the subject of a guardianship, now the court is really interested in what? One major thing, that the property is preserved for the ward. So I just introduced a new word. A person under guardianship is called a ward, W-A-R-D. And so the court wants to preserve the ward's property, and that's their mandate, and the guardian's mandate to account for how that property is being handled each year. And so there is a loss of flexibility in the sense of this. Let's say the person under guardianship could have, and maybe this was not the case, let's pretend they could have, before they became disabled, they could have signed a financial power of attorney, engaged in some form of estate planning, which is not always the case. Some people are disabled from birth and never have the mental capacity to execute a financial power of attorney. But let's say that they had been able to do that. Well, now under that financial power of attorney, which is private, it's a private document that gives a principal, the person giving the power, gives the agent under the power of attorney the authority to make decisions for them and to engage in certain activities. These activities could range from gifting to spending down for Medicaid, or creating trusts, or all kinds of other advanced powers. So when a person does not have that financial power of attorney in place, or does not have a broad financial power of attorney in place, there is a big loss of flexibility that, for example, assets that could have been preserved, let's say that was a goal for that particular family or that particular person. That kind of flexibility to preserve assets and extend assets for Medicaid purposes or other supplemental purposes, that flexibility is generally lost under a guardianship, because the guardianship has one mission, generally speaking, and that is to preserve the assets of the ward as long as possible. And of course, as I mentioned, there's court oversight and annual reporting. So thanks to some of the wonderful attorneys we have out there in the guardianship world in Maryland, there is now an increased training of guardians, an increased training, and the courts have initiated and facilitated increased training for court-appointed counsel and also attorneys who represent clients in guardianship, and for guardians themselves who become guardians of the person and property. There are mandatory trainings, and these trainings have become very, very good and now cut down on the problems associated with guardianships that many of you have heard about or read about in recent years.
Steve, can we pause for a good question?
Yes, Jeff, I'm gonna take a drink of water and listen to the question.
Alrighty. Question is, how long does the typical guardianship process take to implement, i.e., how soon before a child's 18th birthday should one start with a lawyer?
Thank you very much for that. That is a question that comes up a lot. I will say it's going to depend on how that particular circuit court treats this issue. Back in older days, I would say we could start the guardianship process about 60 days ahead of time. And as long as the hearing were to occur after the child has turned 18, then that seemed to be fine. And then recently we've had some experience that the court would not allow, a particular court would not allow the process to start prior to the child turning 18. So I think ideally, hopefully the jurisdiction that we're dealing with will allow us to submit a petition for guardianship in advance of the child being 18, just slightly so, as long as the hearing does not occur until the child has turned 18. Now, with that said, whether the jurisdiction allows that or not, I would strongly recommend that about 60 to 90 days prior to the child turning 18, that's the time to start really getting the petition together, letting you review all the facts and circumstances that have to go into the petition itself, and starting to gear up for that process, even if it's just an uncontested guardianship. I'd say about 60 to 90 days ahead of time is a good time. All right, Jeff, any other questions right now?
No, right now. Thank you so much.
Thank you very much. All right, so let's talk about what families need to ask themselves or individuals before pursuing guardianship. So we talk to a lot of parents and families here at Elville and Associates, as I'm sure many other elder law firms do, about this issue of whether to pursue guardianship. And I'm just going to give you some buzzwords. I'm going to give you some questions here to consider. These are certainly not all encompassing. Every family, every situation is different. Every disabled person's situation is different. All right, is my loved one lacking the mental capacity to appreciate the nature of decision making? Now let's think about this for a second. Many parents and loved ones are very close to the situation with their disabled loved one and maybe don't have a good arm's length view of the situation. Maybe you're so close to the situation that you can't really appreciate truly whether your loved one, and remember, there are people of various levels of capacity. So we have people that are higher functioning on the scale of functionality and capacity, and people that are more of moderate function and lower functioning kind of individuals with disabilities, meaning people who can or cannot appreciate the nature of decision making. So this is a topic that is fluid. It is a fluid situation, and it's an emotional situation. And one of the questions that I like to ask parents, although it's not an all-encompassing question, is my loved one vulnerable? Are they vulnerable to fraud and abuse? Are they vulnerable because they can't appreciate the nature of, money and monetary exchange? Could they appreciate the nature of a contract, which is not 100% scientific, but just really thinking through these issues about whether a guardianship is really needed? And have we explored all options? So we're talking about vulnerability and protection. Do they need protection? have we explored all lesser restrictive alternatives? And the reason that this is important is because not only is the guardianship process emotional and it can be costly, and there are all kinds of things that could, but don't often, but sometimes do go awry in the process. We don't really want to start this process if there are other lesser restrictive alternatives to guardianship that might work. Or is this a situation where there might be some contest? The person that we need to implement guardianship for is not going to agree to it. They are going to resist, and therefore it's going to be a contested guardianship and rather than an uncontested guardianship. So is this a situation where you as the petitioner are going to have to push very, very hard towards a guardianship, but it could be settled outside of a full-blown guardianship? So this is very, very difficult to give you the scope within the limited time that we have today, but these are some of the preliminary questions that I would like you to ask yourself. And if you are so close to the situation that it's difficult to really think through this, you're just so close to it, that's what we're here for, is to be able to, be a third party, to listen and to juxtapose various questions, to think through the issues and determine whether moving forward with an actual guardianship is the right thing to do, or whether another alternative is really the right thing to do. And if we explore another alternative, is it going to really be adequate based on the person's lack of, let's say, ability to protect themselves, or maybe the person does have this ability to protect themselves. So it's a very fluid, very difficult thing to think through. So guardianship and substitutes for guardianship. This is maybe the heart of the presentation today. And let's talk about the most restrictive alternative, and that is guardianship. So let's talk about this process, okay? So guardianship starts with a petition to the court. It starts with physicians or other professional certificates of incapacity, and those have to be timed. There's a timing issue about how long they have to be dated from the time of the petition, or at least one of them has to be more current. And the process is one of submission to the court, working through that process, waiting for something called a show cause to be issued. This is the notice that goes out, and there are interested parties. And depending on how old the person is, if they're under 70 years old, Social Security and the Department of Social Services are entitled to notice, and along with others. And then if they're over 70, the Department of Aging and Social Security are entitled to notice. So there are notices, and there is a show cause order. And in that process, there is a court-appointed attorney that is appointed for the alleged disabled person. This person is not deemed to be a ward yet because they are alleged to be disabled. What does that tell us? It tells us that guardianship is an adversarial proceeding. We are, as petitioners, let's say, we are trying to get guardianship and control over the person or over the person and property of someone who has rights, and those rights are largely going to be stripped of that person. So now that is an adversarial proceeding. And if there is no contest, it will be an uncontested guardianship. Court-appointed counsel and your counsel, if you use an attorney, are going to come to some kind of a consensus that there's no contest. But there is something to remember, and that is that the person who is alleged to be disabled, not only do they have rights, but they have the right to be represented as a person who, to the highest and best degree possible, is to be treated as if they have no disabilities. So this is to give them the advocacy and the right to contest as much as possible so that their rights are adjudicated. Now, when we enter this process, the show cause order basically is saying, does anyone object? And now it's going to move through the process ultimately to an ultimate hearing eventually, where the court will decide whether guardianship should be awarded. And if there's no contest and the judge finds that all the requirements for guardianship have been met, the judge will issue a guardianship order. Okay, so what are the pitfalls and what are the due diligence items and awareness to be aware of? Well, first of all, as I mentioned earlier, there's a process, you engage in that process, and you are acting in good faith. You believe this person needs protection, you believe they're vulnerable, and all of the things that precipitate a guardianship. Maybe they have too much money in their name and they don't qualify for public benefits and they really need those public benefits, and you have to get control of these assets. This could be the case in a brain injury related incident and this kind of thing where someone was living their life and then the next day they were disabled due to a brain injury and now they have to be spent down. That person needs to get control, that guardian needs to get control of those assets and get that person spent down if they indeed need to be spent down to get benefits or therapy and those kinds of things. So there are, the impetus, I guess, to petition. That comes with a lot of emotion. That comes with financial cost. And now we have to go through this process. And the process could be smooth, or there could be an objection. There could be a contest. And what I would like to just point out here is this is a situation where you have to be committed. If you know that your particular guardianship process is going to be contested, you just know that, you're preparing yourself for that, you know what the costs are emotionally and financially. What we want to do is think in terms of, this is going to be difficult, this is going to be emotional, but I have to stay the course. I have to stay the course throughout the process, no matter how difficult it may become, if I'm going to be successful. If I'm going to force, under a contested situation, which I hope you would not have to deal with, under a contested situation, am I going to force a settlement, or am I going to go all the way and into the guardianship hearing with the anticipation of being able to win? So this is a very difficult thing when we cross the line into contested guardianship, and hopefully it would be uncontested and you would not have to be involved in that kind of emotional situation. So go ahead, Jeff, if you have a question.
Yeah, sorry. Thought this might be a good time to pause briefly for a question, if that's okay. How do states differ in their laws, such as seeking guardianship in another state for someone?
Well, thank you for that. I will try to extrapolate off your question about maybe someone is under guardianship here in Maryland and they move to another state, or they move here from another state. So the good news is, although I can't speak for all state laws, I've seen in recent years that laws regarding the transfer of guardianships from one state to another have vastly improved. And now a lot of states, for example, New Jersey, which we've had a lot of experience with recently, and other states that are close by, these states have transferred of guardianship statutes where it's pretty streamlined compared to what it used to be. So just be confident that most likely a guardianship could be transferred from one state to another with not so much difficulty. What is difficult is the underlying benefits that a person might have been receiving in one state cannot always be transferred, and usually cannot be transferred to the new state. So that's really the underlying problem, but the guardianship itself could be transferred.
Okay, thank you.
Thank you, Jeff. Now, remember, we have supported decision-making now. We have a new supported decision-making law from October of 2022, and now we have supported decision-making in Maryland. We're going to talk about supported decision-making in just a moment, but it can be part of guardianship. So to try to make sense of this, even if a person is under guardianship, they could have a supported decision maker, and even though they have lost their rights by definition being under the guardianship, the supported decision-making concept in theory allows a person to not be so much stripped of all their rights, but to still have some theoretical ability to be able to express their preferences under guardianship. So this can be a part of guardianship, and many of you are excited about this or have already read about it. What I'm going to temper your enthusiasm with is that what we are seeing so far, at least in my practice, is that courts are kind of interpreting this. They're not necessarily getting on board with a person under guardianship having a supporter necessarily, unless the court really believes that certain factors are present. And whether we agree with that or not, that's what we're dealing with. But I just want you to know that the courts are in the process of interpreting how supported decision-making is going to be treated under guardianship. And I've been able to firsthand see much of this happening. And I'm sure other attorneys are seeing the same thing. But this is playing itself out about the supported decision-making law that is very broad in Maryland, that allows for someone to have a guardian and a supporter under guardianship, but the courts are interpreting this so far, as I'm seeing, very narrowly. So we'll have to see how this turns out, and you'll have to make your own judgments about it. And that's the new legislation here that Jeff and I have included in this presentation. If you'd like to learn more about supported decision-making, which I'm going to talk a little bit more about, I want you to either read my article on it that Jeff can send you, or read other articles about supported decision-making, and even go to the websites through the state of Maryland that are now describing through the judiciary what supported decision-making is, and that it is an alternative to guardianship. So let's talk about what are the alternatives to guardianship, and let's just go get to it. Financial powers of attorney are an alternative to guardianship of the property. Arguably, the financial power of attorney is the most important of all documents in estate planning. So in hindsight, if we are disabled, we would have said, wow, we wish we had a power of attorney in place, a financial power of attorney, but the power of attorney itself is not going to just be the substitute for guardianship. It's the fact that the power of attorney has agents. You as a principal, or the person as a principal, have appointed an agent, and that is what's important. So under your current power of attorney, we want to make sure we have plenty of agents. I would say in a perfect world, you would have a primary agent and at least 2 other alternatives, alternative or successor agents. And we want to make sure that those agents get along and that you've made good choices, and hopefully your family situation is such that there is no dispute among the agents about how decisions would be made for you. And if you have a financial power of attorney, or your loved one does, has named agents, that should in itself be an alternative to guardianship of the property. Now, sometimes guardians are needed, even though we have those powers of attorney. Let's go to advanced medical directives. Same thing. We have an advanced medical directive, and what is the purpose of it? Well, naming agents, number one, making end-of-life decisions, providing for flexibility, organ donation, final arrangements, pain medication, all of those things that have to do with healthcare related issues. Well, all of that is wonderful and necessary, but the most important thing in that advanced directive is that agents have been appointed. So where we have appointed agents under a financial power of attorney and an advanced medical directive, we now have avoided the need for guardianship. And why is that? Because our agents can act for us privately without the public need for guardianship, without us having to lose our legal rights, okay? So the only way that that is going to break down is if usually the agents don't get along, or other people are impeding, let's say other interested persons in the disabled person's life are impeding the ability of the agent under a power of attorney or the agent under an advanced medical directive from doing what they need to do. And therefore, the private documents, the powers of attorney, the advanced medical directive isn't working. And now the court may find that the disabled person needs a guardian. But all we can do in estate planning is try to get ahead of this issue by avoiding guardianship by using powers of attorney, advanced medical directive. Even though it's not on our list here, I will add another estate planning tool, the revocable living trust. Some of you have a will as your basic testamentary document. Some of you have a revocable living trust. If you have a revocable trust and that trust is funded with assets, which it should be funded with your non-retirement assets, then a revocable living trust also avoids guardianship and is one of the best ways to avoid guardianship of the property, because that revocable trust, like a power of attorney, provides for the management of your affairs if you are incapacitated, because you have successor trustees. So powers of attorney, advanced medical directives, I would go as far as saying revocable living trusts that are funded and have successor trustees. All of these things are alternatives to guardianship and are part of basic estate planning. Joint ownership is an avoidance of guardianship tool because the other joint owner, who is well, can manage or manipulate the assets in the joint account. So we don't need a guardianship for that. Representative payees under Social Security, and many of you are the representative payee for your loved one. Representative payees, they, by their definition, avoid guardianship of the property. The court will say that because the person with disabilities has a representative payee for SSI or SSDI, for let's say, that person does not need a guardianship of their property. And so for those of you who do not have guardianship, but you are the representative payees, that is why you don't need a guardianship of the property. There may be other reasons why a guardianship of the property is needed or a guardianship of the person, but not for the representative payee situation. Consent agreements. This is a little bit of something I alluded to earlier, and it takes a little bit of imagination to understand what I'm saying here. Again, we're in that process of guardianship. It turns out that it's not an uncontested guardianship. It's a contested guardianship. It's everything we don't want. It is opposition. It's a lot of expense. There could be physicians that have to come in to testify. There could be a jury trial. Yes, all of these things can happen in a contested guardianship. But now, as we are heading toward a hearing, a guardianship hearing, where a lot of resistance has been happening between your attorney and the court-appointed counsel, now there is a final settlement of some kind. We might say this is a settlement agreement or a consent agreement that is short of guardianship. So that's an alternative to guardianship that unfortunately sometimes takes a lot of work to get to that point in a contested situation, which hopefully you will never have. And lastly here, we'll talk about supported decision making. And Jeff, I'm just going to go one further slide to make sure that I didn't already cover something here that I wanted to cover. So let's talk about supported decision making in a very fundamental way. And if you are sitting in front of a tablet or you have a blank piece of paper in front of you, I'm going to encourage you to at least make notes or make some mental note of what I'm getting ready to say here. So I want you to visualize 3 categories. And on my left, I would like you to imagine that this is a financial power of attorney and advanced medical directive. This is a person who, on this side over here, this person has the mental capacity to execute these documents. And by the way, many adults with disabilities, many adults with special needs can sign advanced medical directives and powers of attorney to avoid guardianship and appoint agents. These are higher functioning individuals with disabilities. And where we are doing special needs planning for someone like this, it's always appropriate to try to think about how do we deal with incapacity for that person should they have powers of attorney and advanced directive. So over here, that person has signed those documents or has the capacity to sign them, and they're going to do that. So in that situation, we are retaining rights. That person, they have retained rights. They are not giving up their legal rights. Now let's go to the opposite side, and I want you to draw a circle. And in this circle, we have guardianship. So this is the polar opposite. Guardianship, there is a person who needs protection, they're vulnerable, whatever the reason is for their disability. There are 2 physician statements that evidence that they cannot make their own decisions, probably for their person or property. And the court has made a finding, and there's a full-fledged guardianship order or a modified guardianship order that this person needs guardianship. So that person, by definition, generally speaking, has lost their legal rights, subject to some exceptions. And that person could have a supported decision maker. And now we're going to start talking about supported decision making in a minute. But over here, we have a complete loss of rights, or mostly a loss of rights and protection. Over here, we have no loss of rights, the power of attorney, advanced directive, and we have risk. So here we have protection from risk under guardianship. These are very general, very high level concepts. Over here on the left, we have the person has the right to take risks. The person is taking risks every day in their lives. They have capacity, no capacity, risk, by definition, very little or no risk. All right, so those are the polar opposites, and that's basically what we had in Maryland until the advent of supported decision making. So supported decision making started several years ago, and it made its way through various states from Canada and perhaps other places. And at the time, as Maryland started really considering, and there was a movement towards supported decision making by many thought leaders in Maryland, like Megan Rusiano and others. This idea was really just a fantasy in Maryland and really didn't have a lot of traction. It was in Alaska, Indiana, Texas, Wisconsin, the District of Columbia right next door, in Delaware, and some other states. Now we finally have a supported decision-making agreement, and Maryland went from basically ground zero to a full-blown, very broad supported decision-making law that basically says this, and I am really condensing this for today's presentation, and I encourage you to look at supported decision-making beyond just what my description is here today. Supported decision-making to me represents an accommodation. It's an accommodation of a person with disabilities to help them make their own decisions. So to me, if I'm a disabled person, supported decision-making basically means this. I can make my own decisions to whatever extent possible, and that's a big issue, to whatever extent I might be able to do so, provided that I have the support to do so. I can make my own decisions to whatever extent possible, in theory, provided that I have the support to do so. Now, when you think about that, for some of you with loved ones with disabilities, this may be something that makes sense to you, that no matter what a person's level of incapacity may be, remember that fluid line of incapacity, higher functionality, lower functionality, lower cognitive ability, higher cognitive ability, whatever it may be, this may make sense to you that a person now theoretically under supported decision making, which stems ultimately from a United Nations mandate on human rights, that a person with disabilities in theory has broader rights to be able to express their preferences and for the supporter to provide an accommodation for this person to be able to do that. So to me, what Maryland legislature did when it passed this law is it basically spoke for the people of Maryland by saying, we as a society are willing to make accommodations for those people with disabilities, not just privately, like you as relatives would have done that, or a really, really good guardian would have done that anyway. Take into consideration the rights and preferences of a person. That's what we're supposed to do. But this formally recognizes that a person that is not under guardianship, or even a person under guardianship under Maryland law, can have an accommodation to help them make their own decisions to whatever extent possible. The supporter can't make decisions for the person. The supporter cannot go beyond certain limits, but the supporter can provide information and accommodate the person to help them basically extend and expand their human rights and their life experience. So I'm going to go back to the three categories. Powers of attorney and advance directive. Retention of rights, all risk is retained. All rights of self-determination are retained. Guardianship, the polar opposite. Most rights, if not all rights, are stripped of the individual. The individual cannot take a lot of risks because that's the nature of guardianship, is to protect. But in the middle, we have now supported decision making. So what many of you are going to find out is that some of you are not going to be enthusiastic about this because you're going to think that this empowers your loved one with disabilities in ways that you might find threatening, or you are concerned about their taking risks. So let's talk about risks. So the person who has a supported decision maker to help them make their own decisions despite their disabilities, okay, and despite their level of disability, which is a new concept on this fluid line of incapacity or capacity, okay, that person who is allowed to take that risk, that is where we have a little bit of an inflection point. How much risk should a person be allowed to take that has disabilities? So this is something I'm going to let you ponder, that on this continuum of rights, the right of self-determination, over here, no right of self-determination, okay, by definition, and in the middle, supported decision-making, and a person who can sign a power of attorney and advance directive and exercise right of self-determination can also have a supported decision maker at the same time. A person who is under guardianship, subject to the narrow interpretations of the court that we are seeing right now, can have, in theory, a supported decision maker, even under guardianship, to ensure that once you are gone, that the future guardian is under a mandate, in my opinion, to always make sure that the person's preferences are taken into consideration to whatever extent that person can express those preferences. And again, for those of you who are very enthusiastic about this, you might be thinking, well, my loved one under guardianship should have a lesser restrictive alternative and just be able to rely on supported decision making. Let's terminate the guardianship. And guardianships can be terminated, and there are provisions in the law to do that. But the juxtaposition is, if we are going to terminate the guardianship, not only do we have to prove that the person does not have a mental incapacity, but now we're subjecting that person to the risks that we all take every day. The positive of that is that they are able to exercise self-determination, and the negative side is they're going to have risks. But another positive is that risk allows what? The right to be free and be able to make mistakes like we all do. So this is something we're going to see play out in the future, and I challenge all of you to read about it, kind of process how you feel about it, ask questions, and as we explore alternatives to guardianship. Last thing I will say with supported decision making, one of the wonderful things about it as it continues to be explored, and we are seeing this in guardianships as we move forward, is how are court-appointed attorneys looking at this? How are judges looking at this? And do they really see that a lot of guardianships can be avoided with supported decision-making? Well, I think the answer is yes. A lot of guardianships are not going to occur now that maybe would have occurred, and we have to make sure that we're really looking at it from all angles. But one of the nice things is that the guardian, the person under guardianship, the alleged disabled person who has always had the right to be heard in a guardianship proceeding, that alleged disabled person now, more so than ever, will have the opportunity to be heard, because not all courts were treating the right to be heard the same. Many court-appointed attorneys, rightly so, waive the appearance of the person with disabilities who is not going to come to court, is not going to be heard. Maybe they are not able to be heard. But now the court will have to look at all alternatives to guardianship, including supported decision-making, which will make it much more of a level playing field as far as I'm concerned. And of course, there are very, very important guardianship attorneys in Maryland, very busy ones, who are seeing this on the front lines every day. So hopefully this slide with my broad overview of supported decision-making has given you a frame of reference to kind of juxtapose guardianship, or guardianship, I should say, over here, with lesser restrictive alternatives to guardianship and the continuum of self-determination, from full self-determination to no self-determination, so to speak, under guardianship, and vice versa. So thank you for sitting through all of that. This is a basic structure of an estate plan where we see if a person had been able to exercise capacity, they would, by definition, have not only a will, but they would have the powers of attorney or power of attorney document, which names what? Agents, and they would have an advance medical directive that names their agent, so that we avoid guardianship of the property, guardianship of the person. And powers of attorney and advance directive, as I mentioned, are extremely important. Let's just take a quick look again, driving home this concept that Powers of attorney and advance directives avoid guardianship by definition because they are substitutes for guardianship because there is an agent. Now, let's say you have a power of attorney that you never kept updated and you became incapacitated and you had no agent because your agent was either incapacitated themselves or had died. You had not kept your documents up to date. So you could have a guardianship because of a failure of having an agent. We also want to make sure the agents are willing to serve. It is possible for a fiduciary like an agent to refuse to serve. So we want to have more than one agent, and where our loved ones with disabilities have the capacity, we want to be, I would say, progressive and make sure that they exercise their right of capacity, if they have it, for power of attorney and advanced medical directive. Not to mention, as I should say, if I go back one slide, Jeff, not to mention that we want to waive HIPAA and we want to clear the way, if we can, for a person with capacity to allow their agent to access medical records and those kinds of important things that otherwise we would have to go all the way to a guardianship to be able to get those things. This slide is something we don't need to focus on today in the interest of time, but it just goes to show how things really work as we're trying to avoid guardianship and have lesser restrictive alternatives. The healthcare decision-making laws in Maryland is something that you need to be aware of. I would strongly encourage you to go to the Attorney General's website and read about and see videos on healthcare decision-making in Maryland. The Advanced Medical Directive in Maryland is excellent. It has many, many places for personal input and customization, not to mention appointing our agents and making it clear who they are. It's an informal document. You can customize it with your preferences as much as possible. Why? Because if you can avoid guardianship or your loved one can avoid guardianship, we are making ourselves much more so in power of our own future of self-determination. What does your agent know about your healthcare decisions or feelings about healthcare? They don't know anything other than what you've told them during your life. They would just be guessing as they advocated for you. So I strongly encourage you to customize your advanced medical directive or your loved one to customize theirs. So we talked about supported decision-making in a very broad sense. These are more definitive definitions. And I encourage you after today's workshop to really think through this. And we're just going to briefly go through this again. Remember, this is a substitute for guardianship. It's a lesser restrictive alternative in theory, and it also could be under guardianship itself. So it's a tool where a person with disabilities can be empowered, okay? And it's a more formal way of empowering someone under the law. A good example would be a person who's moderately to higher functioning with disabilities. They need to go to the bank to make a transaction. Many people with disabilities have bank accounts. They want to make that transaction themselves. The supporter can go with them to the bank, very simple, and help them make that transaction as they do it themselves to the highest degree possible. This is really being an accommodation for a person with disabilities. This is what is difficult about the Maryland law. It is so broad. It can be a simple agreement. It's a written agreement, or there can be no written agreement. And this is something that parents are having a little bit of a struggle with, that someone who is a little bit at risk, it seems, but they have the right to appoint a supporter under the law with no written agreement. It can be verbal. It can be a formal authority, okay? It's an alternative to guardianship, okay? It is an addition, as I mentioned, to a financial power of attorney or advanced medical directive. It is a potential tool in guardianship for attorneys and judges, okay? It's part of a paradigm shift. So this is the shift now to saying, well, people with disabilities can take risks and should be able to take risks. And again, subject to the limitations of how the Maryland courts are interpreting this right now, it is a new world of self-determination for people young or old with disabilities. We mentioned Megan Raciano and such key players that help push this over the goal line. This is a big, big win for human rights. Now it's really going to be a question of, again, how will the law interpret this going forward? Will it interpret it broadly or very narrowly? And so far, I am seeing that it's going to be pretty narrow. We talked about the old paradigm. It's hard for some lawyers to understand this shift. It's hard for some parents to understand the shift, or other relatives. So that's why I'm going to let you draw your own conclusions about this. So why was supported decision-making needed in Maryland as we continue to wrap towards the end of our presentation? Well, there wasn't a lot of good alternatives, such as maybe just short of a consent agreement. Now, again, remember, a lot of guardianships that are really needed, they sail straight through because there's no contest. But there was no formalized way for people to say, hey, I'm entitled to support or accommodation. And there is no annual review of private guardianships. So the guardianship laws continue to be amended. They continue to be updated based on all of the horror stories that some of you have read, which hopefully are the minority. And we have some really wonderful judges that are trying to make sure they are applying the law consistently. So the old notion, the old culture of traditional guardianship is probably changed forever and is no longer needed. And the culture of what I would call paternalism, keeping people with disabilities from taking risks. And you, in your own particular situation, will have to decide how much risk would you be comfortable with your loved one with disabilities taking, even though that risk by its very nature is their exercise of self-determination to be free and be able to live, as some of us are able to do, with the ability to take risks each day. So what is a supported decision-making not? Well, it is not a financial power of attorney. It is not a way for a third person to make decisions for the person with disabilities. And it doesn't give this third person authority about anything really, other than just to be a support and an accommodation. And it is not a mechanism where the person with disabilities gives up their rights. And it is not guardianship. So hopefully I've made that distinction about this, since we spent a lot of time on this. So what is the difference between supported decision-making and guardianship? Well, again, just to reiterate and be redundant, an adult guardianship removes the rights of the person in general. It removes the rights of the property of the person in general. And it is basically giving them not a lot of legal choice, even though theoretically they still possess some rights, okay? And it is a paradigm that I will call the old culture of protection or protectionism. With that said, some people absolutely need guardianship, and so I am not suggesting that people that need guardianship should not have guardianship and they should not have the protection of a guardianship. But this is just showing the differences. And there is an unspoken consensus of permanency with guardianship. I saw a situation about 5 or 7 years ago where a case went to the Court of Special Appeals, and one of the justices, rightly so, called out that a person under guardianship does not have to be under guardianship forever, and that guardianship could be removed upon a showing of capacity. So going through the process of the statutory requirements. So this is good that our society is evolving and that we're starting to understand these difficult differences between guardianship and the other, lack of guardianship or self-determination issues. And again, what I described with my hands, I'm now going to describe in person. On the left-hand side, we have the power of attorney and the right of self-determination. In the middle, we have supported decision-making. And on the right-hand side, we have guardianship. And these are very general concepts. I encourage you to understand that I'm not trying to be very specific here about any particular situation, but this is a framework within which you can view what I just described kind of visually with my hands. So I'll let you take a look at this and get a little bit of a feel for this slide and what I had spent a lot of time on describing. And then just understanding that our society, our state is still interpreting this. It's going to take a long time for it to shake out, in my opinion. Maybe not as long as I think, but when we start to move to the right-hand side of the screen, I think that right now courts are viewing this very, very cautiously, at least at the beginning. So again, with supported decision-making, there's no removal of rights. There's a potential of restoration of rights if a person is under guardianship, and now this is a lesser restrictive alternative. The rights to property and person remain vested in the individual if they are not under guardianship. As I mentioned, it's more of a paradigm of individual risk, and it can be part of guardianship. It is an addition to a power of attorney and an addition to an advanced medical directive for someone who has the capacity to implement it. All right, well, we're a little bit ahead of time, and that's always a good thing. So I suggest that if you have questions about this, that you understand that we are here to be a resource to you. We believe in education here at Elville and Associates. We hope that no matter what law firm you may be getting advice from, that they believe in education of not only yourself, but of your future fiduciaries, okay, the people that are trusted in your life. Again, there's nothing to fear when you consult with an attorney. There's an attorney-client privilege, whether or not you become a client. At Elville and Associates, we like to review documents if you have current documents, or if you're a guardian and you just have some questions about your responsibilities and what's happening in the guardianship, supported decision-making, we're happy to consult with you about that. If you do not have an advisory team, which is beyond the scope of the subject of today's webinar, we strongly encourage you to have an advisory team of your attorney, your financial advisor, your CPA, and maybe your life insurance professional. And if you have a loved one with disabilities, maybe even a life care manager or advocate. And so we're here to help you put that team together, or if you only have a partial team, we're here to review the team you have and give some advice. We're here to answer questions, okay? But I think most importantly, we're here to help you have a path forward, to really give you time to think and really act as counselors as you kind of think through these issues and have epiphanies about what is the directions or lack of direction to go, different direction to go in. So I'm just want to thank you for your time and attention. That's a lot of information to cover about a very difficult, sometimes emotional subject for many of you. And it was a privilege to talk to you, and thank our special guest for attending today, Jeff. And I'm going to turn this back to everybody and to Jeff for everybody to wrap up. And I thank you for your time and attention. I hope you have a wonderful weekend. Be safe in the snow or the weather that may be coming.
Well, thanks, Steve. Great presentation as always. And my mind wandered a little bit there when you were talking about the advisory team, and I just think about all the wonderful advisors that we're fortunate to work with and share with our clients here. We just had a wonderful breakfast this morning with a financial advisor that does such a great job of taking care of clients. So if you do need a referral for a financial advisor or a life care manager or a good CPA or whoever that may be, you can always reach out to us and we'll be happy to share some resources with you. We do have a few questions. I want to run those by you, Steve. I'm sure you have some good answers.
I hope so.
First question, keep you on your toes here. First question is, what is a range of costs for an uncontested guardianship process for a very disabled child about to turn 18 years old?
Gotcha. Well, court-appointed counsel gets paid no matter what, and the court limits how much they can be paid per hour, and the court-appointed counsel has to submit a fee schedule. And so, excuse me, a petition for fees is what I meant. And so when you are engaged in a process like that with the court, you'll typically see the court-appointed counsel asking for the court to approve their fees, and that aspect of it, you get a chance to review prior to the hearing, hopefully, and you would have an opportunity to object if you thought that the fees were too high, but those fees have to be approved by the court. Now, depending on who's paying for the guardianship, and an uncontested guardianship of your kind that you just described, typically you would pay for that, and it's going to depend on how much time and effort is put into it. A good law firm, I think, is going to use paralegals to draft most of the petition and deal with most of the work leading up to the attorney who's responsible taking it to court. So I would say, just generally speaking, I'm seeing guardianships range from $3,500 to $5,500, let's say, for uncontested guardianships, and that includes most of the time the court-appointed counsel fees, but it just depends on how much time or effort is involved. And what we try to do in uncontested guardianship cases is keep the attorney time down to a minimum with using the leverage of paralegals to keep costs down. But ultimately, the attorneys are responsible for the process and the review and court appearances.
Okay. Next is follow-up from the first question about when a guardianship process starts. What if a medical emergency or other should happen between the 18th birthday and the court hearing? Who makes decisions?
Thank you for that. And that leads me to think that I probably didn't cover one aspect of an alternative to guardianship on the advanced medical directive or healthcare side. And that is the idea of surrogate decision making. So on the financial side, which is a little bit of a digression here, we don't have any alternatives to guardianship if I don't have an agent under a power of attorney. So in theory, if I'm doing estate planning and I don't appoint an agent, unless I have a joint owner or unless I have a representative payee under Social Security, there's really no substitute for a guardianship. But on the healthcare side, in your example where you would be faced with a situation of having to make a healthcare decision for someone who's over 18, you are, in theory, a surrogate decision maker under Maryland law. That child has a surrogate, which is you, that you as a parent are in a list of priority under the law, and you should, in my opinion, under that circumstance, be able to make a decision, not because you're an agent, not because you're a guardian, but because you are a surrogate. And I think under those circumstances, you would be allowed, in my opinion, just over this webinar here, to be able to make a decision. Now, if you weren't for some reason, and there was an emergency that you could get a case walked through, there's always a duty judge. You could get a case walked through an emergency guardianship, hopefully quickly, but quickly means a few days probably in that circumstance. So I hope that surrogate decision making would suffice in that situation.
Okay. Next, if an individual with a cognitive disability can make very basic decisions about preferences using very basic language and pictures, is it fair to say that supported decision making is a good alternative?
Thank you for that. I'm going to give you my opinion, only because I have been schooled in the train of thought from years of talking to Megan Rusiano and other leading disability rights advocates. I'm going to say the answer is yes, because if that person can express preferences, no matter how simple they may be, the idea of supported decision making, taking it to its logical extreme, is that person should be able to be accommodated and supported, even if it's something as simple as I want to go to a ball game, or while I'm at the ball game, I wanted to go get something to eat, and that's what I wanted. Something that simple, which is not what you're describing, but you get my point that no matter what the person's abilities are, or what their level of disability is, on some level, they can possibly express a preference, and that preference should be accommodated.
Okay, thank you. Do guardians need to make an advance directive for their ward?
That's a wonderful question, thank you. So the answer is no, because the guardianship umbrella over that person's life, so to speak, is giving that guardian full power to make decisions subject to certain limitations that have to do with extreme issues in healthcare. But there is no such thing as an advance directive under guardianship, because the guardianship itself supersedes these capacity type documents where, like an advance directive. So a person under guardianship could not have an advance directive that names an agent, because the guardianship supersedes that. But the person under guardianship could have a supporter if the court would allow it.
Okay. And how does one become the supported decision person? Say we, the mom and dad, are appointed guardians over our son when we die. What happens? Can we appoint other guardians, in quotes, once we are gone, that would take over?
Thank you. So what I would do is, if you wanted to explore this idea, first of all, of a supported decision maker, you would have to petition a court to hear you, to ask the court to allow a supporter to be appointed. This is what we're seeing some resistance with right now, and we're seeing some very narrow interpretations of this, which I do not believe are consistent with the law. But we are seeing the law say that any person may appoint a supporter. But we're seeing the court say, well, maybe not, because we don't think this person has this or this or this capability. As long as you as the guardians do not object, the court can consider whether or not that person, your child, can have a supporter under guardianship. To me, if a supporter is appointed, now that provision, let's say, survives your death, right? And that's maybe your concern. I want my child to have a guardian in the future who takes into consideration their preferences and so forth. Now, to give you comfort in this particular area, even if a judge does not decide that your child can have a supporter under guardianship, which would be disappointing, let's say, we know that you're doing everything to accommodate your child's preferences and all of the things that Maryland law and the judiciary websites and the instructions provide, that you're supposed to be, accommodating and providing all these particular preferences and accommodations. We hope that the future guardian will do the same if they're exercising their fiduciary duty. So what's frustrating is typically the court will not allow you to appoint a successor guardian. But what you can do in your own estate planning is you can articulate in your will who your successor guardians will be. So this is how you kind of set the stage for your future successor guardians. And if you haven't already done so, you should articulate that in your will. So hopefully I've answered the question of, how the court generally looks at successor guardians and how you would accommodate that in your will, but also how the court looks at supported decision-making under guardianship right now, which we're hoping will be more expansive in the future.
Okay, very good. We have a duplicate question about the cost of non-contested guardianship. Amy wanted to acknowledge your question. Let me know if you have further questions about that. When spending down, how should the money be spent? Is your question, Steve?
Well, thank you very much. I think that's going to be a case-by-case answer because it's going to be a question of what are we spending down for. Nursing home Medicaid has certain asset limits. The Medicaid waivers have certain asset limits. And it's just a question of what we're spending down for. But generally speaking, spend downs are done to move money into a Maryland ABLE account if the person qualifies for an ABLE account, to buy prepaid funeral and burial, to pay off debt. All of these things can be, even purchase a home for the right person. These are things that, depending on the circumstances and what benefits the person is receiving, could constitute a way to spend down the money. And in a long-term care Medicaid situation, which is probably not what we're talking about here today, Medicaid annuities can be purchased and other things. So it really depends on the context and how much and how, what is it for that we are spending down for.
Okay. And I'm a faith community nurse. Excellent program. Thank you. Rose, thank you for being here. And one more, what about becoming the supporter when there is no guardianship? How to do that?
Thank you very much. So what happens is the person who is disabled and wants to appoint a supporter, they can sign a written agreement. And the state of Maryland, unlike places like Indiana and other states that have provided forms, like the District of Columbia, I believe Delaware even supplies forms. Maryland, to my knowledge, has not created a form. We have created one because that's what the statute says, is that we'd have to create a form. Someone has to create a form that complies with the statute. So we have a written supported decision-making agreement that anyone can basically use. The other side of the coin is no written agreement is required, which is really kind of puzzling to some people, that a person can appoint a supporter or supporters without a written agreement. So I would just say, probably with a written agreement, but it does not have to be.
Okay, those are all of our questions. As far as moving forward here, I will send out our video from today. I'll send out Steve's supported decision-making article that he wrote, also our recent webinar about supported decision-making, and other resources that can be helpful to you from our presentation today. Just a few thoughts about some upcoming presentations. On the 21st of February, we have a new presentation, Understanding Maryland's New Decanting Law, Going Beyond the Vineyard. So that should be an interesting one. decanting a very powerful estate planning tool. On Wednesday the 28th, for our advisors, we have a quick start 2024, hot topics in estate planning, what advisors need to know. So look forward to hosting you for that. And lastly, one of our more popular presentations every year, every 6 months, twice a year, Able Accounts, a financial tool to promote health, independence, and financial security. And we'll welcome Kelly Nelson, the outreach coordinator from Maryland Able, wonderful friend of the firm, and everything she does for the community is just amazing. So look forward to hosting her and you for that presentation and anything else that is of interest to you in the next few weeks. So appreciate you being here today. Have a wonderful weekend and a safe and pleasant day. And we'll see you again soon on the Elville webinar series. Take care, everybody.